At a very high level, what this establishes is that 10 U.S.C. 2377 requires agencies to the maximum extent practicable to procure commercially available technology to meet their needs, and they also have to conduct market research concerning the availability of commercial items before soliciting bids and proposals. Here, Palantir argued that it had a platform, the Gotham platform, that would meet the agency's needs. It told the agency about this in request for information prior to the issuance of the solicitation. So the Army was on notice of its capabilities, that it could provide a commercial item or one that could be modified to meet the Army's needs. After the Army issued its solicitation, Palantir filed a protest at GAO, which denied the protest. They then filed a protest at the Court of Federal Claims, which agreed with Palantir. Government appealed to the Federal Circuit, which agreed with the Court of Federal Claims, that the government had failed its basic obligation to determine whether a commercial item could meet or be modified to meet its requirements. And you can see the explanation of the Circuit's decision here, but the long and short of it is Palantir highlights the mandatory nature of the requirements focused on commercial items at 10 U.S.C. 2377 that agencies have to follow. And the Federal Circuit made this clear and emphasized it both in its language and its holding. And another thing to take away from this case is if you are a company that has commercial products that you think will satisfy agency needs, you should consider establishing a written record and communications with the agency demonstrating those capabilities. That's going to help you substantially if you file a protest at the court. Another significant decision at the Court of Federal Claims is CliniComp International. I won't go over this in great detail. What it establishes is the fundamental obligation that protesters, both at the court and at the GAO, have to establish, which is they have to demonstrate they are capable of performing the contract. And here, the VA had entered into a sole source contract with a company called Cerner to provide electronic health records, or EHR, services at 1,600 inpatient and outpatient VA sites, but CliniComp only had experience at 100 facilities. And it simply had not shown that it had the capability to perform this contract. So this underscores a basic requirement, both at the court and at the GAO. You've got to show that you're able to perform the work required by the agency. And it's worth noting at both the COFC and the GAO, the definition of interested party is the same. It's the definition at 31 U.S.C. 3551, subparagraph 2. And consistent with the holding in CliniComp, GAO has denied protests where the protester cannot establish that it was an interested party because it could not meet the fundamental requirement of showing that it could perform all of the agency's requirements. Very quickly, GAO implemented its electronic protest docketing system, or EPDS, last year. It's mandatory for all protests except for those for classified materials. The system generates automatic emails, and anyone who is authorized to participate in a GAO protest can sign up to register for an EPDS account. My experience, I'm sure Pete and Chris would agree, is that it is remarkably easy to use and that it provides timely and useful notifications. GAO has issued some decisions in the past year concerning the use of EPDS, including those listed on this slide. And the point about the decisions listed here is that EPDS should not be used as an excuse for untimely filings.